Number 1.
Sir, I have entered appearance in this case. I need a little time for preparation. Can it be taken up next week, my lord? Relating to the gradation list of the forester, matter.
The request of counsel for appellant. List on. 23rd March.
Item number 2.
Item number 2, my lord, I am on virtual mode.
Yes.
Item number 2, that is Sarat Parida matter.
Yeah, we'll add 10 more cases today.
My lord.
8th May, same order.
Obliged.
Item number 3.
Wait, please, my lord.
No, there was a mistake of my office, my lord. The specially engaged brief. So probably the clerk thought that the government office will do it.
You wanted to
No, already filed the requisites.
I see. All right. Not you say, Mr. Palit, senior counsel, for the appellant states that the requisites have now been filed. It may be utilized for fresh notice to the opposite party. Respondent. Returnable.
End of March or
No, just you have to go to
subject to your lordship's convenience.
17th May.
No blind.
All right.
Great.
Right.
Item number 4.
My pleasure, lordships. Very serious.
Connected matters listed on 17th February.
Yes, my lord. It was heard at length in presence of the caveator as well as my lord and senior. But it was said that my writ application was dismissed. But my predicament is that 26th is the election. The issue is the nomination of defendant number 2 was accepted illegally in direct contravention of section 828(3)(e). It says that if the society which he represents defaults in making payment, then the nomination has to be rejected. But in similar circumstances, though the minor discrepancies, the election officer rejected the nomination of Dhanardhan Singh and others. But in this case, instant case, he has accepted it. Presumably, the Honorable Single Judge has taken the view that the bar to interfere in the election matters once the election process starts. But my humble submission is, my lord, so far as the bar to interfere is not contemplated here in the Orissa Cooperative Societies Act. The 97th Amendment, Constitution Amendment, which was enacted in 2011, that doesn't contain a provision like 243 or 329 or 243 ZG. But this issue cropped up, the very same issue, bar to interfere, came up before the Honorable Madras High Court, and my lord Justice Indira Banerjee delivered the judgment in a host of writ applications. And it was conclusively held in para 55, which I will produce, my lord, that since the 243A, there is no provision in part 9B of the Constitution of India with regard to cooperative societies.
Which page is the single judge's order?
My lord, that has not been provided as yet.
Still now.
Till now, my lord. Noting is also there. Noting is also there. But my predicament is 26th is the election. I came up, approached your lordship on the non-ability of the presiding officers and the member of the cooperative tribunal. Though I raised a dispute there. My lord, I'm helpless. And nomination has been illegally accepted, palpably erroneous, directly in contravention of section 28.
But the order was pronounced in court.
No, it was declared. My writ petition is dismissed. It was declared in presence of minor senior. My learned senior was there.
The hearing concluded at 5:25 p.m. And after the hearing was concluded, his lordship was not inclined to admit the application and said judgment will follow. And it was on the last Friday, and he challenging the said order, without having a copy of that one. And what is the reasoning given by his lordship?
That's not even, he's equally handicapped.
Exactly. And it was at 5:25 p.m. on Friday itself.
I know, but still.
And it was declared in the court.
So we'll only say that no result be declared. The voting can go on,
Yes.
polling can go on.
Yes, with regard
Result will not be
with
declared.
regard to constituency number 10. With regard to constituency number 10, not all.
Sorry?
With regard to the constituency number 10,
10.
where
All right.
Lordship, just sees this division bench judgment of our.
There are series of division bench
Lordship, I just see, my lord.
that he can only challenge the acceptance or rejection of nomination, only after declaration.
Completion of the result. Hmm.
Lordship sees the judgment, my lord, of the division bench. My lord. And in this, but in the division bench case, my lord, there the petitioner had never objected to the, my lord, rejection of the number or for the, my lord, publication of the electoral roll. Same thing here also, identical. And so, let me complete. And Lordship may kindly see paragraph 16, 17 and 18, 19, my lord, of the judgment. In our considered opinion, the
No,
ratio.
the only thing now, sir, we don't have an order.
Exactly.
So we can't even pass an order in this writ appeal without an order of the single judge.
That's what I was saying. And only para 19, Lordship may kindly see.
No. If what is the original date for which result is to be announced? There must be a schedule, na? Election schedule.
26th is date of election,
Ah.
on which day the result will be declared.
Same day.
Same day. This is a COVID society, this is Apex society, madam.
So we'll keep this on. We can only keep it on 27th, the earliest. 26th is Monday.
Sunday.
Sunday, sorry, 27th. I'm just saying 27th is the only day we can keep.
I mean, this is not maintained, that is the consistent view.
No, I know. Can the result be held over for one day is only question.
But he is also contesting, not that his nomination is rejected, madam.
No.
His nomination is not, there are 8 candidates in the field. He is challenging the acceptance of the nomination of respondent number 2, madam.
Yes. He's
Each
also
candidate is
contesting.
and he is also contesting, madam.
Suppose you win.
So yes,
Then my application will become infructuous, my lord. My lord, but
All right,
it will.
we'll just keep this on Monday. We'll keep this on Monday at 2 p.m.
Yes.
All right.
Obliged, my lord.
So till then, let the result not be announced. Because the polling is on Monday.
Oh, yes.
I'm sure they will not announce the result before 4 o'clock.
No. After 4
It will
o'clock.
be declared on Sunday itself. That is the schedule of the election. Lordship, kindly see.
What do we
Serial number
do?
14.
What do we do, sir? That's the whole problem.
And what is the reason ascribed by the honorable single?
We'll only say it will be subject to this.
Yes.
Yellow.
All right.
Only subject.
All right.
My lord,
We'll only say it's subject to. Sir.
Yes.
Because I'll note all these factors. You say challenging the acceptance of the nomination paper of respondent number 2, the appellant had filed a writ petition, which all counsels appealing for all the parties agree was heard by the learned single judge on 17th February 2023. And an order was pronounced at around 5:25 p.m. that day by the learned single judge, stating that to the effect that the writ petition stands dismissed, the writ petition of the present appellant stands dismissed, and that the judgment would follow. Full stop. Again, all counsel agree that till date, the judgment has not been uploaded and therefore is not available to any of the parties. Full stop. The present writ appeal has been filed. Nevertheless, because the date of polling is 26th February 2023, which happens to be a Sunday, and the results are also expected to be announced on the same day. Paragraph. Counsel for the appellant pleads that the results should be put on hold, since otherwise the writ appeal might be rendered infructuous. Full stop. Counsel for the respondent number 2, on the other hand, relies on the judgment of the division bench in Shri Sulabh Charan Samal versus State of Orissa, 2008, Supplementary 1, OLR 687, to urge that till the result is in fact announced, the occasion for the appellant to question any of the decisions at the various stages of the election process does not arise. Paragraph. the division bench, this court is unable to further examine the appeal in the absence of the impugned order of the learned single judge containing the reasons for the dismissal of the writ petition. Full stop. And yet, with the polling process slated for 26th February 2023, and in view of the prevailing legal position, that cannot be interdicted at this stage. Full stop. The court, while fixing the list on 26th February 27th February 2023 at 2 p.m. Full stop. If by that time the result is announced, it will be subject to the outcome of the writ.
May I have a small prayer, my lord? We have 2 more days, my lord. Tomorrow, Saturday, if the issue can be remanded back to election officer for reconsideration.
No. All that is impossible, sir. No. All right.
My lord, I'm appearing along with Mr. Pradhan, my lord.
All right.
But the result may be with regard to constitutional 10 may be kept on hold.
No. It will be subject to the outcome of the writ.
Yes.
All right.
Item number 5.
My lord, in this case, for Archaeological Survey of India, more time is required to file the affidavit pursuant to your lordship's last order.
5 months is on the and
In terms of your lordship's order,
we
dated,
have to examine the fact that whether the qualification to be reduced. Photographs, sir.
That arrangement is continuing.
My lord,
it is continuing.
it's
The daily
continuing.
lordship passed the order.
That continue.
That's only it continue. Thereafter, my lord, everything chaos. 400 photographers. Here, 150 photographers are there over the appellate. Now there are 400 photographs. Now they have also filed independent writ petition. The only person who have come to
five or seven,
Even it's before the single judge that writ petition.
they have been protected. They have been protected by your lordship's very direction.
Yeah.
protection, your lordship, is not question of my protection. Question is let your lordship's order, which was passed in September, let that be implemented.
That you ask the learned single judge to do that, sir.
Your
That writ
lordship's
petition is not before me.
Your lordship's order, my lord. Your lordship's interim order.
That's right. I'm saying whenever that writ petition is listed, you can ask for that.
No, it's in this writ appeal, para 7, I'll just place para 7, my lords. There appears to be a genuine concern and it is undoubtedly affects the livelihood of hundreds of photographers. Order number 12.
Yes.
Who have been operating as such for decades. In these circumstances, a direction is issued to the ASI to consider the above request of 154 appellants and examine whether there can be a one-time exception provided to those who may not have a matriculation certificate but have been issued the identity cards by the Department of Tourism, Government of Orissa to be concerned for grant of license even in terms of the 2017 policy while fulfilling the other requirements of that policy. An affidavit on this aspect is to be filed by the ASI before the next date. This is that, my lords, that policy is to be tweaked or modified and the ASI is supposed to file an affidavit before your lordship. That is what my learned friend is seeking time. Your lordship may cap it 2-3 weeks or whatever, my
Your
lords,
lordship may vigilate.
and then call it.
In the writ petition, they challenge the policy dated 2007. A policy.
Whom are you appearing for, sir?
I am appearing along with him in
Licensee photographer.
We are the only persons who have gone through the front door, my lord. We are licensed.
And
Review process in 2017 advertisement, my lord.
So what is happening? How are you affected?
We are affected. They are not allowing us to enter.
that
Then
is
licensed photographers are not permitted. No.
Your lordship goes.
So, but you file an application, sir. You file an affidavit. We can ask questions.
Yes, it is also. He has not challenged this circular. 2017 circular was never challenged.
No, Mr. Sargi, if you have any grievance, you file an application, we can then put it to them, they let them reply to
We
it.
have our independent. We have got relief also. That is not under challenge.
Sir,
Strangely, my lord, that order and your
whatever
lordship's interim order,
in this appeal, whatever grievance you have, put it in the form of an application or an affidavit, then we can ask them to respond. On an oral prayer by your,
we have filed a application of stay, my lord.
sorry?
Sorry, we have filed our objection to his
which I have where.
IA 2929.
my lord.
All right, we'll ask him to respond to it. Yeah, yes, please.
My lord wants to know what is the fate of the fate and status of this individual writ petition.
Correct.
I am one of the intervener, my lord, IA number 2, my lord.
Right.
There, when I brought your lordship's order to the honorable single judge,
Right.
the honorable single judge had initially directed you deposit 5,000, you will be allowed. We 40 numbers of photographers deposited 5,000, we are allowed. Thereafter, when I brought your lordship's order passed in this writ appeal to the honorable single judge, the honorable single judge modified its order and merged his order in this writ appeal, my lord. That's why I filed intervention. I want to sail in this boat.
All right, all right.
Your lordship,
My intervention may kindly be allowed.
the stipulation is.
And your lordship clearly directed that it is made clear that the above policy changes is accepted by the ASI will not affect those who have already been granted license under the.
That we made clear.
Yes, absolutely. ma'am.
We have been directed.
They have not been granted license.
No. He has said that this will not affect
Yes.
your clients.
That is pen and paper, my lord. Your lordship.
So you have to file an application, sir. You have to seek for direction.
Your lordship has asked.
Don't simply ask for vacation of stay. If according to you, they're not letting you enter, because in this order, to the contrary, we have made it clear that your right will not be affected.
That's it.
So if according to you, this is being violated, you should file an appropriate application for that.
Your lordship is adjourning this for his response.
For the ASI, naturally, ASI has to respond, sir.
I have got two submissions to that, my lord. A short date may be given, and apart from that, my writ petition, which is allowed, which is not under challenge, and there is a positive direction in our.
You file whatever you have to say. If you've already placed it on record, I'll ask them to respond to
We
it.
have also filed a contempt to that.
576.
Your lordship,
No, no.
only 25176 of 2021.
No, that's not before the DB, sir.
Yes, that is in DB.
For reference, my lord.
No, in DB.
In DB,
In addition to my learned senior, in DB matter, your lordship's order has been violated. Therefore, we have filed 576 of 20.
All right, you say, right at the beginning, you say, counsel for the ASI seeks some more time to file an affidavit pursuant to the order passed by directions issued by the court. Order dated 21st September, is it?
Yes, ma'am.
2022. Full stop.
For violation, we have filed CONTs.
They said affidavit shall be filed positively on or before 1st May 2023. Paragraph. Copies of the said affidavit be served upon the appellants as well as counsel appearing for the interveners, so that they can respond to the said affidavit. Paragraph. The interveners have filed their single court's objection in IA number 2929 of 2022. A direction is issued both to the ASI as well as the appellants to respond to the said objection before the next date. Paragraph. The court is informed that separately, contempt case number
576 of 2023.
576 of 2023 has been filed by the interveners, alleging non-compliance with the directions issued by this court on 21st,
576.
no, 28th September, 28th September 2022 regarding licensed photographers.
No, they
Full
have
stop.
not served a copy. My learned friend probably has not served me a copy of his contempt.
In course of the day, I'm sorry.
It is stated that although in para 7 of the above order, this court had made it clear that the policy changes accepted by the ASI, open quotation, will not affect those who have already been granted licenses under the 2017 policy, unquote, comma. The licensed photographers are not being permitted to enter the monument. Paragraph. The ASI will respond to these objections also before the next date. Paragraph. List on.
It can be hard. Finally, your lordship my permit.
We don't know that. 16th May.
Your lordship,
Grateful.
may I agree that single bench case may be brought in, my lord, for reference, because we specific direction in our favor.
So whatever
That is
you
not
place
under
it,
challenge.
no,
What
but
I'm
you place it
submitting
on record here, sir.
That is there, your lordship did in the objection. Order is already.
In fact, 17th May is better. 17th May.
My lord, please to allow my IA 2 of 2023.
Notice that 2 of 2023 IA number notice.
My lord,
Your lordship may visualize a
Copy may be served by the IS. IS copy may be served.
point of time, there are more photographers than the tourists.
We were told all that last time, sir.
My lord, what is
Something has to be found out. Solution has to be found out. Let them work at it.
My lord, total number fixed at 78. Now 400 people are there.
That's bound in this country, everything is bound to grow. So
No, it depends on you. That
It must be
depends on
regulated,
the
but-
number of tourists.
the footfalls in Konark has gone up, sir, phenomenally.
But it's regulated.
By ASI.
No,
That has
and
been
now if they succeed in removing that sand, the number of visitors will increase.
Yes, yes.
Your lordship may not be knowing. In Puri temple, it is getting its bad name, my lord, because of these pandas and all that problems. Because your lord, here also that is what is happening. So we may lose that status also.
Let's hope that doesn't happen. All right.
The intervention be allowed. Well, our intervention.
Not allowed. The notice is there. All the IA's notice. All right.
Item number 6.
Item 6, your lordship, I am
Okay.
sole respondent. I want 1 week time to file my counter. I am the sole
This
respondent,
counter is not necessary, sir. It's a writ appeal.
my lord, because once of decisions I have to give the
All
copy of
right.
the decision.
There's no need for counter. It's at the request of counsel, the respondent list on. Interim order is there, right?
Yes,
My lord,
yes.
interim order is in his
Is this
favor.
first day order?
No, not.
Archie. All right. At the request of counsel, the respondent list on. 14 September. Interim order to continue.
Prior to that, batch of cases, but this is the.
When is it coming up, this batch?
This is the first case. So batch of cases.
Let it go then.
Item number 7.
May I please, lordship? My lord, in this writ appeal, my lord, respondent number 4 is the main contesting party, my lord. Just now he has served the copy of the counter, my lord.
There's no counter, sir. Writ appeal. Why is the counter rejoinder and all?
Well, he is the main.
We can't have more pleadings in the writ appeal.
The main contesting party, my lord.
It's all right. Counsel to the appellant needs some time to address arguments. List on. Again, 14 September. 14 September.
Well, interim order to continue.
This will say, I don't see. Is there
Yes, my lord, interim order is there, my lord.
interim order to continue.
Item number 8.
Obvious, man.
My lords, item 8, my lords, may give me a
8, my
week's
lord.
time. I'll get ready with this matter.
I
My
will
lords, we call
directly-
it next week. My lords, I'll address my lords.
My
on
lord,
this.
my friend is on any difficulty next week because I am pressing this matter.
Next Friday, my lords.
This is the translated copy of the record of right.
Copy maybe.
Yes.
What is the urgency in these kind of matters?
Because I am unable to sell my for my legal necessity my land. That is what the issue here, my lord.
Value keeps going up, sir. Property
lord.
values.
My lord.
Property values are now again going north.
No, my lord, I am
You
in
must be
distress.
happy.
I am in distress condition. I have to go for my medical and other treatment. That is what my pressing necessity. Otherwise, yes, my lord, if I can retain it, it will face. Any treated convenience, your lordship, I am not. It was in fact heard at length.
The memo filed by the counsel for the appellant is taken on record. You've given a copy to the.
Yes, I skip.
All right. Counsel for the state needs some time to address arguments. Finding time is so difficult, sir, here. April 20th.
My lord, in March, I pray your lordship any time in March, your lordship.
No dates, sir. There's no
On
date.
10th or 9th, your lordship.
Doesn't make a difference. So 1 month will not make a difference. All right. All right. Received from the arbitration center that Shri Kamal Bihari Panda, who was appointed, advocate who was appointed as arbitrator, is recused. The court appoints, we'll have some other advocates, sir.
PR Barik may be appointed.
P.R. Barik.
Yes, ma'am.
All right.
Prakash Ranjan Barik.
Prakash,
Prakash Ranjan Barik as substitute.
Mr. Prakash Ranjan Barik as sole arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims. The arbitration will take place at the AGs of the arbitration center.
Item number 2.
The correction is carried out as pointed out.
Well. Item number 3.
Like item 3, as we have nominated our nominee, it will be.
No copy has been sought on me as of.
Yes, we'll be.
All right.
We'll be intimating them. Let me take this instruction.
Counsel for the state has produced before the court written instructions of a copy of the letter dated 24th February 2023 issued with the Works Department nominating Shri Vijay Narayan Mishra, EIC bracket retired, as their nominee arbitrator. A copy thereof has been handed over to counsel for the petitioner. Paragraph, that view of the matter, there is no further directions called for.
Yes.
Since the earlier directions issued by this court will continue to hold good.
Much obliged, madam.
The application is disposed of. Right.
Item number 4.
Lordship, I want to say, I need 4 weeks time to get the certified copy of the National Appellate Tribunal at Calcutta. Lordship, it will take 4 weeks time. I pray, Lordship, all of.
All right. At the request of counsel for the petitioner. List on 21st April.
Item number 5.
This case, my lord, the arbitration clause is at page 20, my lord.
All right. Notice returnable 21st April. All right.
Item number 6.
Yeah, my lords, I'm seeking some further time because, my lords, I'm asking for some documents from the RP.
Okay. Rejoinder be filed for the next
Hearing for
month.
the respondent, my lord, in this matter by VC. My
Ah.
lord, in this matter, we had filed our reply, my lords, in September. Since
I know.
September, they have been taking.
We'll
time.
give a last opportunity, sir.
Very obliged, my lords, very obliged.
Last opportunity to file a rejoinder by the next date. 5th May, sir.
5th May.
Obliged, my lords.
Right.
Obliged.
Right.
Item number 7.
In this case, the arbitration clause, your lordship shall look to page 13.
No, what Union of India is that? All right.
My lord, kindly permitted to appear to virtual mode, my lord.
Yes, yes. What is your objection, sir?
Your lordship, it is to be fairly submit. This is covered by your lordship's judgment in ABC construction in
Ah.
ARBP 18 of 2022. The
Ah.
only clause that is any member of arbitration will be graduate engineer. That has
Ah.
been already decided, my lord.
Correct, correct.
It can be disposed of in that line.
All right. It is agreed by both counsel that.
My lord, may I pray?
All right, all right. The
My
counsel,
counsel.
sorry, all right.
My lord,
The
please.
only issue, okay, the only issue raised to the counter affidavit is that in terms of clause 25 of the agreement, the arbitrator should be a graduate engineer with experience in handling public works engineering contracts at the level not lower than chief engineer bracket joint secretary level of Government of India. And then 5, 6, who should be appointed?
More than 2 crores, my lord. Justice S.C. Parija may be appointed.
Mr. Justice S.C. Parija, former judge of this court. So just take para 5, para 6 would be Justice S.C. Parija. All right. Yeah, petition is disposed.
Item number 8.
My lord, it is my petition, my lord.
Yes.
Is an application, is a petition under 11, section 11, my lord. My lord, the arbitration clause is contained in page 23 of the petition, my lord.
No, 1 minute.
My lords, I am for the opposite parties. I am entering appearance today, your lordship. I am
Ah.
filing the Wakalatnama.
All
Your
right.
lordship may fix a date, your lords.
All right. Mr. Panigrahi,
For all the opposite party, my
Ah.
lords.
enters appearance for all respondents, seeks and is granted 8 weeks time to file a reply rejoinder the next day. 5th May, sir.
My lord, may I request a shorter date, my lord? That is
They're all holidays, sir. All the Fridays are holidays. in
my lord,
India.
my lord, my lord. My lord. Obliged, my lord.
All right.
Item number 9.
As item 9, I'm seeking the same indulgence as in item 3. Page 276, my lords, they have nominated their arbitrate, their nominee. So my lords may give us 2 weeks time, we'll nominate.
All right. Counsel of the state needs 2 more weeks time to nominate their arbitrator. List on 17th March.
Let me just point it out that this is a last chance to have.
Okay, as a last opportunity.
Much obliged, much obliged.
Because there's a noting that I've not served a copy on them. That I think is not there. So that noting may be just deleted.
It's all right.
Much obliged.
Specialist case admission item number 1. Specialist item number 1.
Let's see, there's some flag report status.
There is a
report.
status report plus.
I'll just see what
Flag
it is. They're all 2018 status reports, sir. Nothing is recent. Very old status.
The matter was listed last one, so that is on 16th April 2019. Order of cognizance is on the challenge.
Anyway, none appears for the petitioners. In all these petitions dismissed for non-prosecution. There was no interim order, I think. I don't think that, I didn't see any interim order. Yeah, no interim order.
Specialist item number 2.
Item 2, may I please? The present petition will also prayed for quashing of the entire criminal proceeding against the present petition maliship. The case arising out of Soro PS case number maliship. The matter has been amicably decided. Amicably settled, and the present petitioners filed
The affidavit of opposite party number 2 and 3 are separately filed, indicating that the disputes have been settled between the parties. In that view of the matter,
that they are married and they are placed to the child.
All the state from the prayer clause stands quashed, and all consequential orders stand quashed.
Obliged.
Specialist item number 3.
None appears dismissed.
Item number 4.
Same order.
Item number 5.
Same order.
Item number 6.
5.
In this case,
In the time of charge mail.
All right, permitting the petitioner to raise all pleas at the appropriate stage.
item 6, my lord.
1 minute, we call it out, sir. We are on 5 now. Disposed. Now item
number
6.
6.
But
Yes,
in
sir.
this case, petitioner challenge order dated 6/5/2017 passed in GR case number 1677 of 2014 at annexer 3 at page 9. Petitioner was a complainant in GR case, wherein charge sheet was submitted by IO on section 506 and 509 of IPC. And Lord Magistrate, OP number 2 has taken cognizance and summoned the accused persons. GR case was posted to 10/3/2016 and thereafter to several dates. And lastly, it was posted to 6/1/2017 for appearance of the accused. And the accused persons were deliberately avoiding to appear before the land court. Meanwhile, OP1, the Home Secretary, issued a letter bearing number 3567 dated 28/1/2017 to Director Public Prosecution at page 7, annexer 1, to withdraw long pending cases up to the year 2015 for category 1, and these are all categorized under annexer 1, and up to year 2014 for category number 1, and up to year 2014 for category 1 to 12, and for category 13 up to 2/9/2016, where despite summons, warrants, attendance of accused could not be procured. This was the circular matter. Public prosecutor and assistant public prosecutor have been instructed to form independent opinion that withdrawal of cases where cases which really subserve larger public interest. Basing on Annexure 1, APP attached to OP number 2 filed a petition on section 321 CRPC to withdraw the GR case, and OP 2 has also accorded permission on 11/2/2017 and discharged the accused persons. On 3/4/17, when petitioner contacted the court of OP number 2, she was told that the case has been withdrawn and the accused persons have been discharged. Petitioner filed an objection before OP2 to recall the order of discharge as it was done in violation of Annexure 1, that is the government circular, as per section 320 CRPC, and opposite, and OP thereupon heard the petitioner and passed orders under Annexure 2. Order dated 6/5/17 withdrawing the case and order dated 11/2/2017 Annexure 2 are illegal and in excess of jurisdiction on the part of OP2 and is against
Sir,
public interest.
Which page of the paper book is the order dated 11th February?
That is at Annexure 2.
Which page of the paper book?
Annexure 2 at page 9. Page 9 of the paper book. At page 9.
What is the date of the order at page 9?
Page 9?
Turn to page 9.
Yes, my lord.
What is the date you see there?
Date is 6/5/2017.
What is my question to you?
Yes, my lord.
What is my question to you?
No, this is the impugned order which I am challenging.
No, come to prayer.
Yes, madam. Therefore, in facts and circumstances and view of the provision of law, it is submitted that your lordship and graciously pleased to admit this petition. Call for the case takers of GR case number 1677 of 2014 from OP number 2, and after hearing set aside, quash the order dated 11/2/2017.
1 minute, just stop. Why are you making a wrong statement?
What wrong?
Why are you making a wrong statement? When I asked you which order you're challenging, you said 11/5 order.
Let me clarify.
9/5 order. And then the prayer clause, you say 11/2 order.
Let me clarify.
When I ask you which page is 11/2 order, you point out to 9/5 order.
Let me clarify the position, your lordship, and kindly allow me to clarify the position.
Just pass it over. We'll call it the next matter. Pass over.
Item number 7.
My lord, because I am on item number 1. I just thought it to propose that your lordship, after a division, I am coming.
Come, tell me, sir.
Item number 1.
Tell me.
Oh, right. It will be called out just now. I will place before your
You're ready. I'm ready. You're ready. Please argue. Kindly come and argue.
I am ready.
Come. Start.
Item 1.
Oh, right. No, it's a case. Before addressing your lordship, only with your honor's permission, I'll take only 1 or 2 minutes for your honor's
Sir,
appreciation.
it's only 11:15 now. You have time till 1:15. All right. Carry on. No problem. Carry on.
My lord, these petitioners before your lordship, they are victimized and implicated in a case on section 379 by 34 IPC, where on the allegation that they committed a theft of their own cattle and cows. The case is like this, your lordship. These petitioners, 14 number, by 14 receipts, by valid receipts from government, they purchased from a government market, government hat of Kansas, 210 cattle. Why? And after purchasing those cattle, 14 in number, about 216 cattle, for their driving them to that through the forest land, they have to seek for a grazing permission from the divisional forest DFO. That they obtained. While they were driving their cattle on the way, one Jasprit Bumrah, he along with the 14 others, at 1 o'clock at night, they came and obstructed them, took away their cows and also the cattle, 216. And they distributed among themselves, among all those villagers. Then all these petitioners, they approached the IIC, concerned IIC, that you see, these are my receipts, valid receipts obtained from the government, and this is the grazing permission from DFO. They have forcibly taken away my cattle. He did not take any action, that IIC. Then they approached your lordship in 14 writ application by way of a CRL MP. In that CRL MP, after going through those receipts, valid receipts and also grazing permission, this honorable court directed that IIC to appear in person. He appeared. Then the question was put by this honorable court by the bench of lordship that what prevented you not to register cases. So who are those persons who have taken away their cattle which they have purchased by these valid receipts? You just register and thereafter you come. While this direction was given, that IIC went and he is the subordinate officer, assistant sub-inspector of police. He himself lodged information against us that the cattle we have kept and given it to Jima, the owners were not found. And I have a registered cases. And he has a registered cases against these owners. That is why I have, on the basis of that, cognizance order has been taken. Against which I approached your lordship for quashing of the entire proceeding. It is there mentioned in the charge sheet itself. Your lordship, may I request your lordship to have a glance?
Yes.
Of the affair at running page 7, your lordship.
Yes.
The police officer ASI, your lordship, to the IIC Jharpokharia PS so and so, submission of an inquiry report. Because that is the direction given by your lordship to inquire into the allegations that they have made that their cattle have been forcibly taken away and they have distributed among themselves. Srimati Manjulata Dei, so and so, wife of Santosh Kumar, so and so, Jharpokharia PS, District Noyagarh, at present, courts ASI, Assistant Sub-Inspector of Police, Jharpokharia PS, begged to report that as per instruction in connection with the PS Station Diary entry number 126 dated 7/9/2016, I conducted an inquiry and it is revealed that on 6/7/9/2016 night at about 1 AM, while some unknown 4 persons, but I submitted before lordship, 4 persons were transporting more than 200 numbers of cattle on foot from Rairangpur side to Sarak Sokha area, which were illegally transported by torturing the cows without providing food, water, medicine, and the rest of slaughtering purpose. One Japrit Luthra, honorary member and the animal, he claims that I am on animal welfare officer, Animal Welfare Board of India, along with her team, followed and they detained the cattle numbering 193 at so and so behind the Sirsa Bazar. But seeing Jasprit Gupta, the unknown transporters had left the spot. Thereafter, Madam Luthra called the villagers gentry, namely so and so, so and so, so and so, about your lordship 28 numbers, and they distributed those cows among themselves. Thereafter, your lordship, as it was old hour, night and there is no communication for safekeeping, he distributed. That is the given in FIR by sub-inspector. Compelling situation. Madam Jasprit Gupta left the above number of cows under the custody of following 85 persons. As per so and so, thus the above facts amounts to be a cognizable offence, but this fact was not reported at PS, as it was stated by Madam Luthra that the identity of accused persons are not known. Are not known and ascertained, and after completion of required information, I report at the PS later on. However, since the incident she was found absent in Odisha, the person who has taken and given distributed among 85 persons, your lordship. I want to refresh your lordship's memory. It is pertinent to mention here that in the meantime, some outsiders, namely Sheikh Baharuddin, Sheikh Khitun, all these petitioners before lordship. So and so, in which they have claimed the above number of cattle belongs to them, and it is strongly suspected that the above noted offenders have stolen or numbers of cattle they have obtained from different places. That is the allegation on the basis of which FIR investigation was taken up. In the charge sheet, your lordship will find, I may invite your lordship's attention at the running page 13, your lordship. That starts with the 13, but the relevant portions, your lordship, is at page at page 30, your lordship. That's the relevant portion. I may place it. During course of investigation, so and so PS case number, during course of investigation, visited the spot, examined the complainant and our other witnesses. The witnesses proved the occurrence, seized the 193 number of cattle instead of 216, your lordship. And by Jasprit Gutra, daughter of so and so of Honorary Animal Welfare Secretary, she claims, and so and so, section 24, Dwarika Road, so and so, that is the address, your lordship, the relevant portions I am giving. So, Sheikh Bahar read and the aforesaid cattle involved accused persons, Sheikh Baharuddin, those who have purchased, Sheikh Baharuddin and Sheikh Kitan, Sheikh Amjad, all these petitions of before lordship in this case. They have purchased, received order sheet dated so and so, Odisha High Court, in Sierra MP number 1185 of 16, filed by accused persons, these petitioners, accused persons so and so, so and so, so and so, and others, in which the Honorable Court passed order and directed that the accused persons appear at PS and produce the voucher receipt, DFO receipt, and the DFO order, etc. As per order, the above 14 accused persons appeared and produced the Xerox copy of their receipt by Bahaduddin and the order of DFO for grazing and before the range officer. Dated 7/9/2016, seized the same in presence of witnesses, prepared seizure list, and supplied a copy of a seizure list to them. This is the receipt you have produced by your lordship's direction in Sierra MP, 1285. Thereafter, your lordship, on so and so, thereafter, by filing charge sheet, he made us as the accused and filed charge sheet on the basis of which cognizance has been taken. That is why I have come before your lordship. And those Sierra MPs, 14 MPs are still pending, where the IIC personal appearance was directed, and he appeared and directed that what prevented him not to deliver those cows to the persons, those are the owners by a receipt they have produced. Now they have not gone to the PS. Now, yes, they will go now and they have gone to the PS, but the IIC, by that time, she was transferred and the another IIC told that I do not know about the order, but they filed that. That is why I have come before your lordship. All right, that's all.
Permitting the petitioners to raise all pleas at the appropriate stage in the trial court. The petitions are disposed.
Item number 7,
Item 7, my lord, no instruction.
No instructions dismissed.
item number 8,
None appeals dismissed.
item number 9,
9, your lordship, both the matter, no instruction.
No instructions dismissed.
item number 10, item number 10,
None appeals dismissed.
item number 11,
No instruction.
No instructions dismissed.
item number 12,
No instruction, liberty may be granted.
No liberties. No instructions dismissed.
item number 13,
None appeals dismissed.
item number 14,
None appeals dismissed.
item number 15,
None appeals dismissed.
item number 16,
None appeals dismissed.
item number 17,
None appeals dismissed.
item 18,
18, my lord, the matter is in fructus.
Dismissed as instructions.
item 19,
Actually, file is missing. I pray, but that after tracing out to the file, I may, the
Yeah,
liberty may granted to
Yeah, yeah.
move afresh.
Yeah. File dismissed for non-prosecution with liberty to revive the petition if the file is traced. Right.
Yes, ma'am.
item number 20,
Item number 20 on behalf of the HN Mahapatra. File is misplaced, my lord.
Same order.
Same.
All right.
Obliged, my lord.
item number 21,
Item 21, may I please, the present petitioner challenging the quashing and set aside the order of the mallersip, the criminal posting against the present petitioner, the allegation against the present petitioner, mallersip, there is that the complaint has given 14,000 to the present petitioner. Instead of returning that amount,
Permit you to raise all pleas, permitting the petitioner to raise all pleas at the appropriate stage.
Ma'am, yes, ma'am.
item 22,
None appeals dismissed.
item number 23,
None appeals dismissed.
item number 24,
None appeals dismissed.
item number 25,
I am on his similars. The petitioner has filed this application for challenging the order of cognizance under section 394 of ICC, and the grounds taken maybe I pray the grounds which are taken maybe petitioner may be allocated at the time of charge.
Right. Permitting the petitioner to
liberty.
raise. Yes, same. All right.
item 26,
None appeals dismissed.
item 27,
None appeals dismissed.
item number 28,
28, no instruction.
No instructions dismissed.
item number 29,
None appeals dismissed.
item number 30,
None appeals dismissed.
item 31,
None appeals dismissed.
32,
My lord, item 32 raise all the point at the time of charge.
Yes, permitting the petitioner.
item number 33,
I have filed the requisites, my lord. Original receipt is
That's all right, sir. What's the matter about?
matter is after
Taking cognizance, what's the offense?
294, 506, 34 section 3 of SCST.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. All right.
item 34,
None appeals dismissed.
item number 35,
All matters order be communicated to the concerned lower court. Yes, same order. Dismissed from opposition.
item number 36,
Same order.
37,
Same order.
item 38,
None appears.
item number 39,
39 months. Lordship will see, I'm challenging the whole proceeding here. It starts from page 7.
Yes.
It's an order passed by the learned JMFC Bhubaneswar, issuing, directing to, referring the matter 156(3) to the
Unless you
police to
settle the
register.
matter, sir, these are all compoundable.
Not only that, my lord. The whole complaint, if a lordship will see.
But you have to get the other person. See, the problem is now on your say so, we can't interfere. See, these are matters where you should enter into, I mean, if you are able to enter into a compromise, well and good. Otherwise, you have to face trial, sir.
Lord, if a lordship sees the complaint petition itself,
Yes.
I have basically two things to say before my lords.
Civil dispute being converted
Not only
to criminal.
civil dispute, a pure money claim.
That's what.
He says that I have sold iron rods.
Sir, all this is done so that you will pay up. That's the whole point.
But it can't be, the criminal law
It's all
can't be
known.
triggered.
This is a standard thing, sir. That's why.
There are
Then
two documents, if I can satisfy your lordship.
permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
Item number 40.
This is the petitioner challenge. The dismissal of my revision application under Annex 6 at page 25 which arises under 125 proceeding mallet.
Yes.
Initially, the petitioner challenged the order of maintenance passed by the London court below. And
You're the husband.
I'm the husband.
What is the maintenance, sir?
Maintenance award has been that initially it
What is
was
the amount? You are so hesitant. Obviously, it is not a very substantial sum.
2,500. But petitioner is not getting the salary. You'll also kind of glance at annexure 4 mallet. That is at page.
And you have a child.
Yes.
What is this?
But I am not getting
2,500 you can't pay for a child also. Even for a child it is enough.
Provided I will get the salary mail. I am not
Even
getting
a child cannot survive, sir.
But I am not getting the salary mail. We also can appreciate on the under annexure 1, this
Yes.
court has pleased to reduce the amount, and subsequently the order was challenged by the wife, and subsequently the magistrate was without appreciating the same enhanced the same to 2,500. And you also can glance at for a second mail. Page 19 mail.
You are aware of the Minimum Wages Act? You are not aware.
Yes. The petition, my predicament, I am not getting the salary mail. That is what because for a second.
Just imagine the plight of your wife.
Yes.
If you are not getting salary, just imagine her plight.
Page 19, the petitioner is not drawing the salary since 2013 mail.
All right. I'm sure because of the pendency of this petition, you have not paid her anything.
No, I am ready. Till 2016, I am paying. Till 2016, I have paid.
Today we are in 2023.
Yes, ma'am.
How did she survive last 7 years? Have you thought of it?
But it has been enhanced to 2,500. And
the challenge in the present petition is to an order dated 27th December 2017 passed by the Additional Sessions Judge Balangir in Criminal Division number 225/01 of 2012-17. By the impugned order, the learned ASJ dismissed the Criminal Division petition filed by the present petitioner, questioning an order dated 20th April 2012, passed by the JMFC Balangir in CMC number 134 of 2000, enhancing the monthly maintenance payable to the respondent wife, opposite party wife, from ₹400 to ₹2,500 per month. Paragraph. Admittedly, the couple have a child, which is the child, and the child is with the mother. Full stop. In the circumstances, in the considered view of the court, the enhancement was justified because the earlier maintenance of ₹400 per month was granted more than 15 years ago on 7/10/1993. Having heard learned counsel for the petitioner, the court finds no grounds made out for interference. The petition is dismissed.
Item 41.
None appears dismissed.
May I take the liberty to make a submit in that matter, my lord? I got the instruction. The 156(3) police has submitted a final report saying that no case is made out. So lordship may give me some time. I can give that document to your lordship and address your lordship on that. If the case is already not there, then
all the more, sir. Then
so I just
whatever you argue there, you argue.
I'll just since the case is not there, trial will not be there also. So police has submitted a report saying that no privacy case is there.
Then
so I'll just
ask for a
get that.
discharge. On that basis, you can
Right,
ask
sir.
for a
I'll
discharge.
just get that paper. Madam.
No. You can ask for a discharge. Sorry.
No, discharge is not there. The case even not there, madam. Why should I ask?
Then all the more, sir. Nothing to worry about.
So that submission may be recorded.
All right. Mr. Ratha informs the court that The police have submitted a report
Yes,
saying that no case is made out.
yes,
This will be brought to the notice of the trial.
that's right.
All
That will end up the.
All right.
Great.
Item 41,
None appears dismissed.
item number 42,
None appears dismissed.
item number 43,
Prefer an adjournment on behalf of Divedi. His grandmother expired yesterday.
What's the matter about, sir? Where is your paper
I
book?
have no instruction.
Why are you asking for adjournment without paper book?
Lordship, he just intimated me to take adjournment.
Problem is you are in the court where simply you can't go and take an adjournment. Very big problem.
Lordship.
You tell him, sir, you're sending me to a court where adjournment and all is impossible.
Next week.
Just call him up. I'll pass it over. You call him up and say, why have you sent me to a court like this?
Lordship.
Heartless judges sitting. Please tell him that. All right. Pass over.
item number 44. Memo.
Memo taken on record. Dismisses withdrawn.
Item 45,
May I please, Your Lordship? Item number 45, 46, 47, and 48.
Yes.
All are identical matters. Because of some dispute in money transaction, FIR has lodged. All the petitioners were employee of the institution. Now are the employee of the institution. Matter already been settled. So that I need only 1 week time to file joint affidavit before this honorable court.
You've not even made them party. How will you file joint affidavit? You've not even made them party.
I may be permitted to impute the
No,
party.
no. See, all that you have to
Very
thought of
silly
earlier.
matter.
Go to the trial court, sir. Just tell the trial court that. They'll record statements and close.
A very small matter. All
That's what.
petitioners will-
Just go once to the trial court, tell the trial court all this, it'll all get closed. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court, the petition is dismissed. All right.
item 49, item number 49,
None appears dismissed.
item 50,
नहीं Lordship.
Hmm.
Last time है ना ये status report होता था.
No, sorry, out of 21 charge sheeted witnesses, 14 have been examined.
How many?
14 plus.
So he can now be released, sir. Only IO is left.
No, 21, out of 21, 14 have been examined.
14.
1 point.
This is what circumstantial evidence case. All right.
Accusing the custody.
All right.
7, 11, 20, my lord.
All right. Counsel for the petitioner, learned additional government advocate informs the court that 14 prosecution witnesses out of 21 have already been examined. Full stop. The applicant has been in custody since?
7, 11, 20.
7/11/2020. Full stop. Considering these factors, the court directs that the petitioner be released on bail, subject to the satisfaction of the trial court. The application is disposed of.
item 51,
Return of pressman. Dismissed as not trust.
item number 52,
I'm with the opposite party members. None appears to the petitioner dismissed.
Lordship, on behalf of Mr. Pusti, Lordship, Mr. Pusti is ill, your Lordship. Keep to next week any day, your Lordship.
What's the matter about, sir?
I have not gone through the file.
The proceeding under section 138 of the NI Act. Lords,
any settlement possible?
Settlement, Lords, accused has filed this application. Lords, one application has been filed before the court below, saying that the income tax officer may be called for to depose, Lords. So that has been rejected.
Oh, all right. So counsel, the petitioner is stated to be unwell. List before the roster bench. 25th April. All right.
item number 53,
Please, your Lordship. Lordship, here the petitioners prayed for quashing of the criminal proceeding on the ground that no case has been made out against the present petitioners on section 490 406 506 34 IPC.
490
490 and the petitioner is the husband, mother-in-law, 70 years.
Unless there's a settlement, sir, you'll have to go for the trial. There's no settlement here.
No settlement.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
item number 54,
May I please, your Lordship? My Lord will kindly turn to Annexure 2.
Annexure 2 is the informant statement to the police where he had lodged the FIR. The petitioner is alleged under section 364 for kidnapping the daughter of the informant. But she was 26 years old. They were in love and they are married. Currently living together. That is the status.
Where is that affidavit?
Annexure 2, my lord. Page 16.
No, this is not. No, this is the father.
The father is the informant.
That's right, sir. This is the affidavit of the father.
Yes, he
Where
had.
is the girl's affidavit?
The girl is living with the boy in today's date also.
Where is her affidavit, sir?
Sir, in the previous occasion, in the previous order, my learned senior was asked to obtain instruction regarding the informant and the daughter's status.
Why can't you? They're living
I-
together. You should have no problem in getting her affidavit.
My lord, I had just asked the husband. He said that's why in the next date I will get the affidavit in a week.
This is the question. Are they actually living happily together or?
They are, my lord. They are still.
Then why are you not producing the affidavit?
Because I was not asked to, my lord, if
Please.
kindly, my lord, will.
All right, counsel, the petitioner needs time to produce the affidavit of the daughter of the complainant.
My lord.
He claims that both the petitioner and she have been married and are living happily together. At his request list before the roster bench on 26th April. All right.
Obliged, my lord.
Item number 55.
None appears dismissed.
Item number 56.
Your lordship. So the main proceeding out of is this criminal miscase arise has already been disposed of by the learned court below by virtue of the settlement, lordship. 138 matter.
Counsel to petitioner says the petition has become infructuous in view of the subsequent developments. It is disposed of.
Item number 57.
None appears dismissed.
Item 58.
58, my lord, I'm appearing for the opposite party, my lord.
None appears for the petitioner dismissed on all options. All right.
Item number 59.
Item 59, your lordship, on behalf of Mr. Devi Prasad Tripathi, if your lordship may kindly grant some more time.
For what?
Your lordship, we are not able to get in touch with the clients
This is a company. How can you not get in touch?
So that we can obtain instructions, your lordship. Please, your lordship.
1 minute. Some inquiry was asked. Notice has been served or not? The report of the District Judge Baleshwar reveals that against the protest petition on the protest petition filed by the petitioner complainant on 26 September 2017, the SDJM Baleshwar passed an order on 1st December 2017 rejecting the protest petition on the ground that the final report has already been accepted by the Mega Lok Adalat after proper service of notice to the petitioner. Paragraph court notes that the prayer in the present petition is not for quashing of the aforementioned order dated 1/12/2017. Full stop. It is also noted that full stop, unless that order is challenged, the court cannot possibly grant the relief of setting aside the order in the National Mega Lok Adalat. Full stop. Permitting the petitioner to file a fresh petition, if so advised in accordance with law. Assailing the above order, the present petition is disposed of. All right.
Obliged, your lordship.
Item number 60.
Matter is compromised by both the parties. My lord, I have filed the IA. Today, I have original, I have not filed, test of filed today. So the matter kindly add.
Counsel to the petitioner claims that the matter has been compromised and needs some time to place and record the relevant affidavit.
No.
Please go to the roster bench. On 19th April.
Item number 61.
None appears dismissed.
Item number 62.
None appears dismissed.
Item number 63.
None appears dismissed.
Item number 64.
Memo taken on record, dismissed as withdrawn. Both cases.
Item number 65.
65 on the petition, my lord. It's a very small matter. There is a prior rivalry between this petitioner and the opposite party, my lord. What has happened in the para 3 of my petition, my lord, the factual background leading petition is that on 18/11/2017, one Pramila Behera, wife of Banka Behera of Fatehgarh, PS Fatehgarh, Nayagarh, lost a report about the ISC that it was alleged that on 16/11.
All this, you should try and settle these matters, sir.
Trying to settle, my lord, is 379.
You can't even get an affidavit
Nothing
from your
has-
neighbor.
Nothing has
Same village neighbor.
My lord.
And this is the problem if you keep fighting with your neighbor.
Can I suggest, my lord? Can I suggest, my lord, them let you appeal for the variation?
You go there, sir. There are mediation centers everywhere now.
You
Don't
don't direct, my lord.
all the way, don't pull them to Cuttack. Now there are mediation centers in every district.
Please, my lord, not direct, my
You
lord.
go there, Kendrapada, no?
Yeah, my
Or
lord.
Khandapada.
Khandapada, my lord.
Khandapada. Anyway, everywhere there is now mediation center.
Kandarpada. Direct for mediation, my lord. Direct.
No. You see, counsel the petitioner states that he'll approach the trial court with the offer for mediation with the complainant, permitting him to do so and to urge other pleas as at the appropriate stage the petition is disposed of. All right.
Item number 66.
None appears dismissed.
Item number 67.
None appears dismissed.
Please, Lordship. Here, I have challenged the initiation of the annexure 1.
Mm.
Can I have a glance to the annexure 2, page 16, my lord? There was a settlement revision petition filed by the
468, 471 and all, you can't settle, sir.
No, but there is a-
Non-compatible. 468, 471 is not compatible.
No, my lord, there is a direction.
Those are offenses against the state.
Yes, ma'am. Now, there is a direction from the competent civil court to approach this civil judge for settlement, my lord.
How can this be
right.
settled, Mr. Guru? You know criminal law much better than everybody else.
My lord, here what has happened, my lord?
468, 471 can't be settled, sir.
There is, my lord, that is, kindly have a glance to the annexure 2, my lord. It is a.
Anyway, you urge all the pleas. Permitting the petitioner to urge all pleas at the appropriate stage. The problem with all your forgery and all that is this.
But there is a lot of sale deed was executed prior to, and
That's a problem, sir. That's a problem. All right.
and there is a direction to approach the civil court. Without approaching the civil court, he has filed the FIR, registered the FIR. That is the.
All right.
Item 68.
68, my lord, kindly turn to page 12, my lord. There is
Yes.
a compromise petition. And I have paid all these monies which I have received. The matter has been compromised, my lord.
Where is that other man? This doesn't look a very convincing compromise petition, sir. You have to record the statement properly.
My lord, there is a report from the district judge, kindly 6 at,
It's still pending. All pending for appearance of your appearance, for his appearance. This kind of compromise is not very convincing, sir.
I
You
have
to file
had,
affidavits. You go before the district judge and do all that. Get the statements recorded. All right. Get the statements recorded on oath, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. All right.
Item number 69.
May I please?
And this application with a prayer to quash the proceeding, my lord, in view of compromise between the parties, my lord.
You're appearing
They
for
are
the
the fact already filed.
all right. Counsel appearing for the complainant confirms that there is a compromise arrived at between the parties Your affidavit is on record. The affidavit of the complainant is on record. In that view of the matter, take from the prayer clause and all proceedings consequent thereto hereby quashed. The petition is disposed of. All right.
Item 70,
None appears dismissed.
item number 71,
None appears dismissed.
item number 72,
Dismissed is not dressed. Disposed of is not dressed. All right.
item number 73,
We just say memo taken on record. Disposed of is not dressed in terms thereof. None appears dismissed.
item number 74,
None appears dismissed.
item number 75,
Item 75, Mr. R.C. Behra is not well. So 1 week time may be given.
What's
Only
the
next
matter
week.
about, sir? AD not back.
Custody matter.
Custody. What's the age of the child now?
I prefer only next week, Lordship.
Counsel to the petitioner stated to be unwell. List before the roster bench. On 2nd May.
item 76,
May I please, your lords? Here in this case, my lord, the petition challenged under the order dated 14/3/2018 order annexed 2, my lord. That is the order of cognizance, my lord. And your lordship may kindly see, this is a case under section 138 of the NI Act, my lord. Neither the petitioner has issued the check, nor is the account holder, my lord. And so far the special act is concerned, my lord.
Yeah, you urge all the pleas, sir. Permitting the petitioner to urge all pleas at the appropriate stage in the trial court, the petition is disposed of, interim order vacated. The trial court be informed.
item number 77,
None appears dismissed.
item number 78,
78 permitted to withdraw, your lordship.
Disposed of is withdrawn. All right.
item number 79,
79, the matter has been compromised before the court below. I am filing memo. The order should.
Counsel to the petitioner has placed before the court copy of an order dated 7/12/2021 passed by the Family Court Parla Khimundi, recording the compromise between the parties. Whereby the parties have decided to live peacefully. In that view of the matter, take from the prayer clause and all proceedings consequent that are hereby quashed.
item number 80,
None appears dismissed.
item 81,
Memo taken on record, disposed of is withdrawn.
item 82,
Lordship, I am assailing the order dated 21/10/2017 for taking cognizance of the offences under section 493, 497 and read with the 3(1) WIA.
497 is adultery.
yes,
Lordships,
497 is adultery.
497. Now, on the ground that all the ingredients of the offence has not been applicable in the present facts and so.
Raise it all at the appropriate stage, sir. Permitting the petitioner to raise all the pleas at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated.
item 83,
None appears dismissed.
item number 85,
May I please, your lordship?
85,
sorry, 84,
84.
pardon, 84.
May I plead your lordship? Lordship, the father is the informant here. The petitioner come before lordship for quashing of the FIR. The person who is the alleged kidnapper and the person who alleged to be kidnapped, both are the petitioner before lordship. During the investigation, lordship, the petitioner number 2 has filed an affidavit with the SDJ Matagad, but he says she has in her own violation come with petitioner number 1, lordship.
What has happened subsequently?
No, they are staying together or you can instruction from the local council today. If lordship direct, they can file the fresh affidavit.
Counsel, the petitioner states that she is prepared to file a fresh affidavit to the petitioners to stay that to the effect that they are now staying together.
Lordship.
List before the roster bench on 3rd May, interim order to continue.
Okay.
Item number 85.
May I please your lordship? Lordship kindly see, informant already filed the affidavit before this honorable court. Matter already been settled.
Settled. All right. The informant has filed an affidavit in this court stating that the disputes have already been settled between him and the petitioner. In that view, the matter takes from the prayer clause and all proceedings consequent thereto are hereby quashed.
Obliged, my lord.
Item 86.
May I please your lordship? Lordship, here I am challenging the order dated 5/4/2018 passed by the Special Judge Vigilance. On the date of judgment, he so moto, your lordship, recall PW2 under section 311 of CRPC, your lordship. Lordship kindly say the case is posted on 11. Lordship got it on page 15, your lordship.
Was there a stay here?
Stay here, your lordship.
Where? Where is the stay?
The
Oh, I
stay
see. All right.
Lordship kindly see the case is posted on 11/4/2018 for judgment. At the time of preparation of judgment, it was found that documents such as bill registered number so and so, book of drawal, letter number so and so, left in the Jima of Srimati Annapurna Sahu, the then CDPO. The said documents were not produced before the court at the time of trial, which are required for the just decision of the case. So at the stage, this court felt it proper to exercise discreting under section 311 of CRPC suo moto. And
anyway, sir, what is the prejudice? Now you can cross-examine.
Your lordship kindly see, the date is fixed for judgment. Before that, the argument was over. Written note was given.
You will anyway cross-examine this witness. Now 5 years has gone. How has it helped you? Your misery has gone on for 5 years now. You yourself got it stayed.
Your lordship.
Now more misery for you now.
Lordship kindly see,
What is hanging in your head for 5 more years now because of your stay?
Lordship kindly see what prejudice is giving me. I have opened up.
You have caused yourself prejudice, sir, the last 5 years. By now the case will be over.
But at the stage of judgment, your lordship, it should not be 311 should not be used to patch up the prosecution lacuna, your lordship. That's the judgment of the court in number of cases.
When did the case start? When did the trial start?
It's a case
FIR of which year?
2008.
No, sir. FIR of which year?
2018, your lordship.
Then,
sorry, your.
No. FIR has to be much earlier, sir. 1999 case.
Yes, sir.
99.
So what were you doing for 17 years? The record and all not produced. We can't for 17 years keep hold on to records, sir. This is a trial. It's not casual. This is PC Act, no?
PC Act.
PC Act. How can you do this? Charge sheet must have been filed in 2000, 2001 itself. You have dates? Give me the dates.
Before that, also the judgment was. Lordship kindly see. Before this date, also the judgment was kept. On 17/3/18, also the accused person of present, the Lawrence defense counsel are present. Heard the argument of both sides, put upon for judgment. Then also the prosecution asked for time.
Correct. The challenge with the present petition by the accused is to an order dated 5th April 2018 passed with the Special Judge Vigilance Sambalpur in TR number 54 of 1999, whereby invoking the power under section 311 CRPC, the trial court decided to recall for further examination PW2 and also take on board certain documents Full stop. The grievance of the present petitioner is that the case having been registered way back as PS case 57 of 1995 on 17/12/1995, and with the case having actually been fixed for judgment on 5th April 2018, there was no occasion for the trial court at the last minute to invoke the power under section 311 CRPC. Full stop. Paragraph. Counsel appearing for the Vigilance Department does not dispute the fact that charge sheet was already submitted in the case way back on 30th September 1997, sorry. And the question of admitting fresh documents for the purposes of trial more than 20 years thereafter was perhaps extraordinary. Paragraph. The court notes that the offenses for which the petitioner is being tried is under section 13(2) read with 13(1) small c of the Prevention of Corruption Act 1988, as well as sections 465, 468, and 477 capital A read with 34 IPC. Full stop. Charge sheet was filed way back on 30th September 1997 itself. Full stop. Accompanying the charge sheet should have been all the documents that the prosecution was relying on. Full stop. After conclusion of the entire trial and when the case was listed for judgment, the trial court decided to permit the prosecution to place and record more documents. Full stop. There's every reason to believe, as contended by counsel to the petitioner, that this was an attempt by the prosecution to fill up the lacuna in the trial of the case. Paragraph. In the considered view of the court, the above circumstances are telltale. Full stop. If for 18 years the prosecution decided to keep back documents and then produce them at the last minute, only to somehow postpone the conclusion of the trial, such an attempt should not have been encouraged by the trial court. Full stop. In other words, given the circumstances where the case was already more than 20 years old, the trial court ought not to have lightly entertained the plea of recalling one of the prosecution witnesses, (PW2), and taking on board new documents not forming part of the charge sheet. Consequently, the court sets aside the impugn order dated 5th April 2018 and now directs that the matter will revive before the learned Special Judge (Vigilance) Sambalpur, and will be listed there on 17th April 2023. Full stop. The case, that is TR number 54 of 1999, will resume from the stage at which it was, namely for the vigilance judge now, after hearing arguments of both sides, to once again pronounce the final judgment. Full stop. Considering that this is an old case, the trial court should conclude the hearings and deliver judgment within a period of 3 months from that date. The petition is disposed of in the above terms. A copy of this order be sent forthwith to the concerned court.
Item number 87.
None appears dismissed.
Item number 88.
Memo taken on record. Disposed of as withdrawn. Both matters.
88 and 89. Item number 90.
May I plead, Your Lordship? Here is a case, Your Lordship. The petitioner in custody since 2020, more than 2 years and 4 months.
He says only 201 he's been charged.
Lordship.
No,
Lordship, I mean,
circumstantial evidence, of course.
No. Only offense as far as he's concerned.
I'm sorry, Your Lordship. The charge was under section 302, 201, and 34 IPC.
Last time you said only 201.
Yes, Your Lordship. Enter what the enter evidence, Your Lordship. I was not participated in the crime, Your Lordship.
No, but you should not have said. Then you
Yes, Your
say he has been charged only under 201.
Exactly, Your Lordship. After obtaining the certified copy, I came to know, Your Lordship. After obtaining the certified copy, Your Lordship.
You can't make a misleading statement, sir.
Sorry, Your Lordship. I have obtained the certified copy.
Counsel with the petition. How long have you been in?
2 years, 4 months, Your Lordship.
Trial has not commenced.
No, comments, your lordship.
Trial comments.
Trial comments.
Trial comments, when 12 witnesses have been examined out of 21.
36, your lordship.
36, sorry.
Is he one of the main accused?
Yes, Lord, he is the main accused.
He is the main accused.
Maybe circumstantial evidence, but he is the main accused. Lord.
But all independent witnesses have been examined.
Yes, your lordship.
That part, plus, of course, I have not examined out of 14 who are.
Find out, sir. Counsel for the petitioner today corrects the previous statement made on the previous date and states that the petitioner has been charged under section 302 and 201 read with 34 IPC. Full stop.
My management should supply deposition copies, Lord.
Already supplied, your lordship.
No.
2 times I have already. The content.
Where is that order framing charge you have not produced?
Yes, your lordship. That's the certified copy, your lordship.
This is order framing charge.
Yes, your lordship.
I see. The order framing charge dated 5th October 2021 bears this out. Full stop. Paragraph. It is stated that out of 22 prosecution witnesses, 16 have been examined.
36 out of 36, 14 have been examined.
Out of 36 prosecution witnesses, bracket PWs,
Sorry, your
14 PWs have been examined.
out of 34 statutory witnesses.
Okay, 34, 14 have been examined. All right. Paragraph. Counsel learned AGA seeks time to inform the court whether all the independent witnesses have been examined. That is request list on 3rd March.
My management is directed to supply the deposition copies. Isn't it whatever whoever the witnesses examined, he can supply because he must have the.
Yeah, I'm having twice I have already supplied.
One deposition be furnished by counsel for the petitioner to learn the AGA. All right.
Diplo,
Pastor matter item number 6. Item 6.
To clarify the prayer. In the prayer, the order dated 11/2 2017, 2014, sorry, to 2017 and Annexure 2. Annexure 2.
Where is that 11-2, sir?
My lord?
Where is that 11-2 order?
It has not been annexed to us.
11-2 to.
Where is that order?
But this includes, this Annexure 2 includes that order.
I am not able to find it. You show him the paper.
It includes Annexure 2, includes that order.
Where is that, sir?
I am placing Annexure 2.
No, that doesn't include.
At page 9.
Page 9 only 6/5/2017.
What? 6/5/2017 is the order, but wherein the earlier order by which the case has been.
You have to say if you want quashing of an order, you have to enclose copy of that order.
In that case,
you do whatever you have to. You say the order dated 11/2/2017, of which the petitioner is seeking the quashing of, is not on record. Counsel for the petitioner needs time to produce the said order. List before the roster bench on 4th May. All right.
Pastor matter item number 43. Item 43.
None appears dismissed. So the endowment commissioner wants 3 more months' time, sir. But I don't know that letter.
Right.
It's July 22 letter. I don't know if it's still valid. So there's a letter from the Commissioner of Endowments dated 11 July 2022 seeking extension by 3 months for disposal of OA number 42 of 2007 under pending under section 25 of the OHRE Act. So since the 3-month period is already over, the request made in the letter seems to have become infructuous. Therefore, no orders are called for. That's it.
I am from Puri cabin.
All right, sir. All right.
We are very happy.
Thank you. Thank you. Thank you. That's right. Namaskar, sir.
Namaste, sir.
For orders item number 1.
Item 1, my lord, I have filed IA for entry bill, my lord. Report was completed.
Yes, continuous dialysis is being carried out in Apollo Hospital, Hyderabad.
Hyderabad.
Father of the petitioner, my lord, suffering. Kidney disease, my lord.
Apollo Hospital, Visakhapatnam.
So he has to move out of state.
But they are undergoing treatment there.
See, dialysis is being conducted at DHH Rayagada.
Oh,
Rayagada.
Yes.
All right. The medical report, as forwarded by the IIC Muniguda PS, indicates that the physical condition of the applicant's father is serious, is very serious. And the dialysis, and he's undergoing dialysis at DHH Rayagada twice per week. Full stop. In the circumstances, it is directed that the applicant be released on interim bail for a period of 3 weeks, sir.
1 month. 1 month.
All right. 4 weeks from the date of his release, subject to the satisfaction of the trial court. All right. The application is.
Item number 2.
The application for restoration of the rent, which was dismissed for default on 1/11/2019.
And you filed it in 22.
Yes, since we are not there subsequently.
No. Delays. The delay in filing the restoration application is extraordinary and not satisfactorily explained. Consequently, the delay is not condoned. The ECM appeal is dismissed.
No limitation application is also.
Right. Right, sir. Right.
Sir, no.
Thank you. Thank you.
Wait, please, Your Lordship.
1 minute, sir. Namaskar, sir. Pranam.
Orders item number 1.
But I have filed this application for little clarification so far as the order dated 10/2/23.
We had asked the keys to be deposited DRT.
Yes, but here also what has happened, but I am in possession of the property of the owner of the property, in fact.
Oh, you are the owner.
Yes, total 9 apartments
Tenants.
are there.
Ah,
Out of 9, I am staying in one of the apartment. 8 apartments were given to OICL. OICL also taken the key from me and they are residing there and maintaining it. But after this, Your Lordship directed them when they say that they are going to quit, the tenants, Your Lordship, and their rent was being deposited in DRT. They wanted to hand over the key, but instead of approaching us, they hand over the key, filed an application here. Unfortunately, with due respect, Mr. Niranjan Lenka, who was there at the council, you could not be there because his name is mentioned N. Lenka instead of his full name. He could notice it. But he was not there and couldn't bring it to Your Lordship's notice about the real fact. The keys have been given to DRT to deal with the matter as such. But here the question arises, but unless they give us the key and unless the building is maintained, but because it is all lock and key. So these are all turmeric is there in Bhubaneswar area, Your Lordship knows, and also cleaning it, maintaining it, or putting it to rent even. The rent can be deposited
but you can apply to the DRT, sir.
But DRT may not entertain my application.
No, we'll ask them to entertain your.
Unless Your Lordship actually.
Yes. We'll permit you, sir.
Yes.
This is an application by the.
Your Lordship.
Huh.
May I please?
Yes.
Your Lordship, we are the auction purchaser into it.
Yes.
Right now, we are holding the auction purchase. We have taken it from the bank. So if Your Lordship see the purchase agreement.
Exactly. I wanted to bring Your Lordship notice. The auction purchase was challenged. The Honorable Debt Recovery Tribunal Appellate Authority have stayed it. They wanted to take possession because the district judge has returned the.
So anyway, you're there.
Your Lordship.
Yes, I am in possession.
No. So you can let them decide your application, sir.
Yes, that is exactly Your Lordship observed.
Let the DRT take a call.
Your Lordship, we are having right now the.
We won't foreclose anybody's submission, sir. You make your submissions.
Unilateral arrangements.
No. I'm saying you make your submissions with the DRT. He will make his submissions. So the DRT take a call.
Your Lordship.
That's what we're saying.
Interest.
So once the matter
That's
goes,
right.
it's hardly 1.5.
We'll only clarify that our order will not prevent him from applying to the DRT.
Interestingly,
I have already deposited the key before the DRT on 20th.
Right.
Interestingly,
yes,
but their money has been directed to be refunded to them. That is why they are before Your Lordship.
I see. Yes.
The appellate authority said no, possession cannot be delivered because I have already paid more than 75% of the outstanding dues to the bank.
Oh, all right. Anyway, you see, Mr. S.P. Mishra and senior counsel appearing for the applicant states that the applicant is the owner of the premises.
In possession also.
Who claims to be in possession. And he accordingly seeks a clarification from this court that the applicant can approach the Debt Recovery Tribunal Cuttack (DRT) for appropriate orders regarding the handing over of the keys to the premises, which have now been deposited before the DRT pursuant to the order dated 10th February 2023 passed by this court in IA number 912 of 2023. In this petition paragraph, counsel for the auction purchaser, however, expresses reservations stating that the issue concerning the inter se rights of the auction purchaser vis-a-vis the original owner is still sub judice before the DR80. Full stop. Paragraph. In the circumstances, it is clarified that the order dated 10th February 2023 passed by this court will not prevent the original owner, that is the applicant herein, from approaching the DRT for appropriate directions regarding the keys to the premises. In such application, it will be open to the auction purchaser and any other party to make their respective submissions, which will then be decided in accordance with law before the DRT, by the DRT. All right. The application is disposed of.
Right. And also regarding induction of tenant.
Right. Handing over the keys and induction of tenants.
Right.
All right. All right.
Thank you.
All right. Right. Right.
Sir, Pranav.
Namaskar. Namaskar.
Orders item number 1.
May I please, Madam?
Yes.
Your Lordship, sir, please to allow my writ appeal and had remanded the matter to the Tehsildar. That was in view of a circular.
You wanted the ASO.
ASO, and he has to record my name. That is in terms of the directions of Your Lordships in this case of
Narottam.
Narottam.
All right. All right. for the reason stated therein, the application is allowed. The order dated 2/1/2023 passed by this court is modified by directing that the concerned assistant settlement officer will carry out the directions of this court and not the Tahsildar.
Okay.
All right.
In terms of the judgment in Narottam.
In terms of the judgment of this court in Narottam Ratha. All right.
That is writ petition 1608 of 2000.
Yeah, they have all that. Yeah.
One more, Manoj. There are 3 other applications identical to this one because 4 appeals were disposed of on the same day.
So you have those, then we'll take it on board and pass the same order.
368, IA number 368 of 2023 till 371. 68, 69, 70, 71.
All right.
Obliged.
You'll just have to give us copies of the applications.
I'll have it handed over to the.
All right. All right.
Just before coming up, me and my learned senior, we had gone to the new copying section. The learned senior said that now this is a place where people would want to work.
That's the whole idea. That's the whole idea.
Highly, your lordship has changed the face of our work. And we are very grateful for that.
Thank you. Thank you.
One feels like coming back to this place over and over again.
Correct. Right. Right.
Item number 2. So if I may, your lordships.
Yes.
My lord, this is an application seeking a modification in the cause title. My lords, we are pleased to grant the bail, your lordship. But my lord, after...
Right. Just for the reason stated therein, the correction be carried out and the corrected order now be uploaded.
No, my lord, there's no defect in the order. My lord, the cause title page which comes out independently, my lord, on that, my lord, the wives...
The cause title in the order
your lordship
be corrected as indicated in the application. Right?
My lord, that may be, my lord, I may take that as an addendum to the application. That is all that, if your lordships may state.
All right. We just say the cause title of the appellant of the appeal be amended as under. All right. All right. And this accordingly be reflected in the cause title in the order.
Your lordship.
All right. All right. All right.
I'm grateful, ma'am.
All right.